All right, well, here we are. It's 3 o'clock, so I want to go ahead and get started today and welcome all of you to the Anatomy of the Sixth Amendment webinar. Thanks for joining us today. I'm Kate Denman. I'm a Senior Program Associate with Defender Legal Services at the National Legal Aid and Defender Association. Just to give you a quick background, what we're going to do today is we're just going to share this new interactive planning exercise that was developed as part of the BGA Sixth Amendment Initiative, for which we here at NLADA serve as a training and technical assistance provider. The project seeks to help jurisdictions uphold their obligations under the Sixth Amendment. So we hope that, at the end of today's conversation, you're going to come away with an understanding of how this Anatomy of the Sixth Amendment exercise works, ways it can be used in your jurisdiction, and then we're going to help connect you with the resources you need to help undertake this exercise yourself. So just a few quick housekeeping items. I just want to quickly note before we start with today's panelists. We're going to be linking in the chat to all of the resources that we referenced in today's conversation. During the presentation, if at any point you guys have a question, throw that into the chat. We're going to be keeping an eye on that. We'll elevate that up to the panelists so they can get a response back. And then also at the end, we're going to put in a link in the chat for a very short survey, I promise, very short, just to fill out about today's presentation. So with that, let me start with just a quick introduction of today's panelists. First, we have Paul Lovelis. He's the creator of the Anatomy of the Sixth Amendment exercise. He's Systems and Operational Manager with the Pima County Public Defense Services. He's originally from Pima County, graduate at the University of Arizona, and he's been with the Public Defense Services since 2005. Next, we have Megan Page. She has been the Chief Assistant Pima County Public Defender since 2018. She also graduated from the University of Arizona College of Law, and she clerked with the Pima County Superior Court before joining the Public Defender's Office in 2011. And finally, we have Daniel South, who for the past 4 years has been the Bureau Chief of Community Protection at Pima County Public Attorney's Office. First joined the office in 2012 as a trial attorney in the Special Victims Unit in Major Crimes. Prior to that, assistant prosecutor in Cuyahoga County, Ohio, after graduating from Cleveland State University, the Cleveland Marshall College of Law. So with that, I am going to turn this over to Paul so we can get our discussion started on how you all can take this tool and use it to help out all the stakeholders in our criminal justice system to think about and further the discussions regarding the rights under the Sixth Amendment. So Paul, take it away.
Great. Thanks, Kate. I also want to just thank NLADA for hosting this and also just being a technical assistance coordinator for all of this. They've really made sure that the website is easily to use and they've really kind of walked it through, making sure that it's something that can be handed off to others since the original design. Also the Center for Court Innovation, they were our technical assistance providers as a part of our BJA grant. They also have really helped us in just working with the results that came from this activity and then also helping spread it throughout the rest of the country. So we're grateful to them. And then of course, Bureau of Justice Assistance for funding this grant, which is sort of how this activity all got started. We really, attorneys, we generally don't start thinking initially about what everybody else can do. We oftentimes are like, well, what can we do better? We're always trying to improve ourselves. And so I was nervous that our focus would be too much on the part that we believe is extremely important of the Sixth Amendment, but we also believe all of them are well balanced. But of course, the access to counsel, it's something that we continually look at. We also recognize where our access is being limited or hindered upon. And so I wanted to make sure that there was a conversation that really involved the entirety of the Sixth Amendment. And so that led me to sort of reflect on, because of my history background at the U of A, it led me to reflect on, well, what was James Madison originally thinking? And sort of at the beginning of the video. That resulted in me diving into some different versions of the Sixth Amendment. And ultimately, I realized that aside from one attorney in my office, an appellate attorney, team leader, who would be very interested in talking with me about that for a few hours, nobody else would care about all the different versions and the past historical references to it. And I also recognize that really the original authors of the 10 First Amendments really had already done this. They've already looked at the different versions, and this is the one they came up with. And so I kind of went back to, okay, so here's our Sixth Amendment. It's actually much more complex than just access to counsel. And then I started to discover, how could I lead a conversation that is very engaging and very much powerful to the people in the room, and not just something where perhaps one or two powerful voices end up speaking about, all the issues, and then everyone just sort of joins on board. And so that's sort of how this began. And so from that, and we'll go into what that activity looked like, but from that, it was a great success. We then I gave that information to the Center for Court Innovation, who thought it was a really great exercise just in general. They started using it with a couple of other grantees of the same cohort of the BJA grant. And then from that, NLADA really wanted to try to make this something that's sustainable moving forward, and that organizations could actually, embrace and then take on, no matter what kind of capacity they have. We recognize that different jurisdictions have different skill sets within their departments, and most specifically too, some jurisdictions they don't have someone who is able to facilitate these types of things. They don't have those types of skills, and so we wanted to make sure that this is something that anybody could take on within their jurisdiction. And so there was a lot of intentional conversations around that, and NLADA really took what was originally done here in Pima County and then built it into this website tool. So I'm going to go ahead and kind of move into the tool, and I'll talk a little bit about the activity as we go through it, and share a little bit more with that. So let me just switch to my Chrome. I originally thought about doing a PowerPoint, but I felt like it was just not going to be the same. So first of all, the website for this overall capacity building is called strengthenthesixth.org. So strengthenthesixth.org. And in particular, if you scroll down, just past a few of these, there's another way to get to this, and I'll reference it in just a moment under the learning tools. But just for easeability of finding it, if you scroll down to tools for learning, there's the anatomy of the Sixth Amendment exercise right here under the tools for learning. And again, there's the learning tools up here as well, and then you can go into the module from that way. Also, if you write down strengthenthesixth.org, you can also just add the /articulate, and that'll get you here as well. So some of the, what this was essentially built to do was to walk you through the activity. Now you could do this a couple of different ways. For one, you could actually use this tool in the room with everybody, with your stakeholders and with your participants. Or you could do this, you could watch this video, follow the activities, maybe from an office area, because you might be doing it in a meeting room at this point, probably after COVID is over, but you could be doing it in a meeting room where there may not be internet and or the right resources. So we've designed it so that it can be done both ways. And I think you'll see that as we go through. So again, this is really about a self-assessment. And I want to reference that we did it initially as a self-assessment as public defense services, because we were the ones who did the grant application. We also just sometimes, some of the lawyers feel that it's, there's a better, trust amongst ourselves and not having everybody in the room And so initially, we did this just with our own, but I want to point out that we did do it again later with a larger group, and we'll hear both from Megan Page and down south about that. But this self-assessment could be for a department, and it could be for the entire system. I actually think that there's strengths in both, and perhaps doing it a couple of different times could be something of value as well. But it really is a self-assessment for your jurisdiction. So when you click on Introduction, it'll take you to a video. We're not going to watch the video now, but you could go and listen to that. It essentially walks you through what I've just kind of talked to you about, how this was formed, and then also why you would want to do this. So as you continue, it talks about, what are you doing well in your jurisdiction? It's always important to start out the conversations with what's positive. And this is one of the things that you often learn in facilitation, but try to get some positive things going. It makes people feel good about what we're doing. Oh yeah, we actually are doing some things well. So that's always a great way to start. If you're somebody who's maybe not the director or the supervisor, but maybe a line individual who wants to make this activity happen in your jurisdiction, these are just some top talking points that you could talk about with them as to why this should be done, and get your stakeholder involvement early. After that, we'll go through the activity. What comes out of this activity is a number of different things, but it varies by every jurisdiction. But I want to also point out that while it varies by jurisdictions, there are also a lot of jurisdictions who have probably similar issues that come from it. And so we gave some options, some different things that came from our activity, as well as from another jurisdiction, I believe in South Carolina. And so you can take a look at what's next there. And then moving on, this is again just sort of the intro to the tool. This is where it actually gets into how do you do this. So there's some instructions here. There's a PDF that you can download. And again, you could actually print these out if you're someone who likes to print. I'm generally not. I do not print. As most of my coworkers know, I'm much more of a digital person, but we did make it a PDF so that you could print it out, take it to the room. And I'm actually going to walk you through a couple of the things in the PDF. First of all, there's just, again, this background. We talked about this, most especially the complexity of the Sixth Amendment and the fact that there is a right to a speedy trial, to an impartial jury, to know and understand the specifics of your charges, to be able to face your witnesses, to hear from witnesses in your favor, and then again, of course, to have counsel to assist you. And when you really think about all of these different things, they're actually quite different. And that was really what I wanted to try to get out of this activity. And so we sort of lead the facilitator, if you will, through that kind of thought process and why it is important to look at each of these individual items. And again, we talk about why to do this. With the instructions, it's clear about what kind of materials are needed. And then also after that, how to use these materials. So, I mean, it literally is step by step. There's a brainstorming conversation, breaking our groups into larger groups. So what we did initially with our internal people, and then also with our overall criminal justice system stakeholders, is we took the large group, broke them out into 4 or 5 people per group. And then we essentially placed the different portions of the Sixth Amendment across the room initially, and then had the groups sort of walk from one station to another so that they could kind of even get in their mindset that they were moving from the speedy trial section over to the impartial jury section and so forth. In the second group that we did with the criminal justice, we were doing it in a more neutral setting in a room that was a little bit harder to have been able to move around. So we just had the group sort of sit still and then just said, okay, we're moving on to the next section. I will say that I personally recommend, if you're doing this and you have the ability, do it in a room where you can set stations for each portion of the amendment. And the reason I say that is when our larger group was doing this, the full criminal justice system stakeholders were doing this, some of them felt like they were done with the right to speedy trial. So then they started moving on. That's fine. I will admit that even in our internal assessment, some people just stopped talking about the topic and started talking about life or whatever it was that they wanted to talk about, but at least there was some acknowledgement that you're still in this section. Maybe you could help force the conversation a little bit longer, give some more time for some people to sort of still process this through their brains. So if you have the option, I really recommend putting stations throughout the room. If you follow the instructions here under step 3, there's 3 basic questions that we ask at each station. Number 1, again, what does our jurisdiction do that ensures these people receive this portion of the amendment? Because it's each portion that's being broken down. It's essentially a strengths, weaknesses, and opportunities. We didn't really have any threats sort of identified in here, and this is essentially your strengths. And again, I think it's important to start with this because it always just kind of helps the conversation get a little bit more open when everybody's understanding that, yeah, we all agree that there's some good things going on in our community. And then secondly, what does our jurisdiction do or not do that might hinder this portion of the amendment? And so then kind of moving into your weaknesses and then moving on into your opportunities with what can our jurisdiction do differently to improve this portion of the amendment? And then also with this, it sort of starts to bring into how you could potentially impact some of the things above, you'll find. And we have it all broken out here with this page as far as the different amendments. As you move on, it's really important to make sure that the groups can kind of report out with each other, that they're able to talk to each other, kind of feed on it a little bit. The facilitator needs to make sure to balance that to some degree to make sure that everybody still feels open to be able to divulge everything that comes out. But I think it was really great to have some conversation and some dialogue amongst the groups as they were sort of bringing things up. And you'll find that sometimes some of the same stuff has been brought up multiple times. So that's one thing that you'll notice. And then what you'll want to move into after that is how to do your voting. And you could do this a multitude of different ways. And we talk about some of the ways how to vote. So for example, you could use the sticky dot approach, as a lot of people do, where you have all the options listed on walls. You can move sticky dots around. We actually used Everpoll in our initial internal self-assessment so that people could vote on those things digitally. I really personally recommend digital. Again, I'm generally against paper. Even prior to being against paper, I was always kind of a digital person. But the most important reason that I actually like the digital version is that it allows for people to feel more anonymity, in the sense that they could say that they really like something over another. Versus with a sticky dot, you still end up with sometimes everybody noticing that there's 7 dots already at one item. And so they kind of feel like if they don't put a dot at that item, that they might be judged by other individuals in the room. And so I personally like the digital anonymity. You could try to do the voting anonymously through paper ballots or something, but do what you can within the time frame that's reasonable, because obviously if it takes too long to vote, people are going to just get bored with that. When you're going into your findings and next steps, this is the portion where it's really going to be important to get away from the voting, let the voting happen, come back another day, sort of have a fresh mind, and really start to explore what are the common areas here? Where do we see certain reactions, certain things that have been identified, maybe things that are identified across multiple portions of the amendment that are similar in nature and how we're hindering or how we're doing something really well. And so by kind of taking a break and letting your mind just refresh, you can actually start to see those things a little bit better as opposed to sort of being focused in. And so I really recommend taking some time, letting people have a break or doing it another day. But the most important thing is to make sure that your stakeholders in the room as you're going through your findings and next steps, and even prior to this really, is a diverse group of individuals. Not only is it that, some line individuals, but you want some mid-level managers, you want some of your stakeholders to be directors. If you can even involve stakeholders as clients, victims, etc., that's even a greater benefit. Maybe there's some community members. Because when you get into these portions, this is really where you're going to want to have individuals that know what's going on the ground every single day. And if you have a bunch of directors in a room, they might come up with some really great answers that we all know end up being something that's really hard to actually accomplish in the long run. Our next step with this, just so you know, is to actually take what we put down and move it into what our goals and objectives, and then into a logic model. So we've taken our strengths, our weaknesses, and our opportunities. We've taken it from sort of a context of dissecting the Sixth Amendment and what's happening. We've moved it into some goals and objectives that we want to accomplish, either for this project, for example, with us, with a grant, but you could also be doing this sort of as just a commitment to make some reform in your community, or to try to bring about some new focus. Maybe you have some new stakeholders in the room. It's been quite a few years since everybody's talked about what are our goals and objectives as a criminal justice system for our jurisdiction. And so you're taking those goals and objectives and then you're making it into a logic model. And I don't know how many of you on this call know what a logic model is. Some of you might, some of you may not. Some of you know that you know enough about it to know that you don't want to know any more about it. But the logic model is really the key to getting grants and to taking your goals and objectives and moving them into actionable items, and having a clear plan and sort of concisely written out who's going to accomplish these things and how are we going to know that they're accomplished with our outputs afterwards. And so almost all of our grants that you apply for require a logic model for good reason. Logic models really ultimately help you in accomplishing things moving forward. But we really wanted to make sure, and NLADA kind of put this together so that you could click on this and see an example of a logic model. And I'm not going to click on it here, but you can see it in the documentation, where you can then go and look at how would you take this information and put it into a logic model and then build some action items and some action plans from that. So I kind of wanted to, I'm not going to go over this entire thing, but I just wanted to show you the worksheet. It just essentially has each section broken out and then with the questions down there. And so this is literally a tool that you could just download, begin your activity, you know, watch the videos if you want a little bit of summary of what the instructions are at the top. But the idea is it engages you to just be able to go out and do this now. So going back to the online tool for a moment, you have your instruction worksheet. This is also a template for an Excel sheet. I'm not going to open it up and show it to you. It's an Excel sheet. It's got some grids, but it allows you to understand how you could document all of the items that come from that. And so I really recommend using both of these tools together. It sort of helps organize everything. And then it highlights again the materials needed that were already included in the instructions. This also walks you through the reporting and voting. Again, we already talked about this a little bit, but it really just kind of walks you through the entire steps. It was talking also about taking a break. If you really like the look of those cookies and that coffee, NLADA will provide you, no, I'm just kidding, they will not provide you, but you know, I really recommend taking a break. You know, it's important to just, you've had all this conversation in small groups, you're about to vote on these issues, really want to just kind of take a break and then move back into it afterwards with sort of some fresh minds and some energy still willing to go towards this, because it's been an exhausting part of the whole day, just to put everything down, you know, on paper or digitally. So we even wrote that in there on the taking a break. And then walking through the voting exercise. Again, this is the digital version, and then there's the PDF version. They really are the same thing. It's just to kind of help you walk through it step by step in a room if you wanted to. And so we just offered up all these voting options. There's another short video that again just kind of summarizes some of the things that I've talked about. The idea being that maybe they won't have you know, someone to kind of explain why a logic model is important or what these things will walk you to. After that, we talked about finding and setting priorities. I want to just go into, you know, to say that one of the things that I really found valuable about this activity was that as an administrator, it's really hard sometimes to get everybody to come to a room and talk about, you know, what needs to be the biggest priorities, and then not have the biggest issue that's so important but almost impossible to achieve not be the top item. And so it really helps to kind of have these broken out into that Excel sheet and really talk about how easy is this? Is this a really easy thing, like a low-hanging fruit, as you call it, a medium style project, or is this a really difficult project that maybe we want to make it into like a 3-year type project with the lower hanging fruit, something that we could work on this year? And so it really, I think, allows for people to kind of recognize, you know, this is going to take a long time. We won't see success. We won't necessarily have our satisfaction from this for some time, but these other things we could get some short satisfaction from. but meanwhile feel like they're also working towards the longer term goals. So as I said, there are some examples here on the website. There also, Bureau of Justice Assistance does offer some more technical assistance resources and ideas there. My recommendation really is to take a look at the example and just kind of see like, okay, so this is what it should be looking like when I'm done, so that you can kind of get an idea for that. If you've already done some facilitation, you probably know what this will look like, but again, we're really wanting to make sure that this is available for everybody. So this is the tool in a nutshell. You can actually, it actually kind of keeps where you are if you allow it to accept cookies. So it'll actually know that you were still in the instructions phase. So if you were actually using this in the room, it'll remember where you're at during that time. And then you could just refresh and start back from where you were. But the important thing is to really just have this available for you so that you can do it in whatever community you're in. So I now wanted to just kind of move into, how did we see this as a benefit? And instead of just kind of letting you continue to listen to me, I actually wanted to call on two of the people who were in the room, who really, I think, probably saw a lot more of the benefits from it than even I did. And so I was first going to just go ahead and ask Megan, if you could just talk, you did it initially with the first assessment for public defense services, and then also later with the criminal justice system. If you could talk about your experience with the first time doing this, what were your initial thoughts as a participant?
I thought that it was really useful to do within the department for several reasons. And I will say that doing it within the department isn't, depending on how your organization is set up. Our department consists of various different offices, conflict offices, overflow offices, and then also the office that manages contract attorneys. And so it was helpful to get people from various positions in all of those offices together to try to see, what are our priorities as a whole department. And one of the things Paul mentioned about having, management, but also line attorneys, we had paralegals participate. And that was really useful because as we broke down the Sixth Amendment, there were some things that paralegals had a very unique perspective on that, the line attorney may not think about, or that the supervisor may not think about, and vice versa. I also think, like Paul mentioned, the Sixth Amendment is much more complex than the right to an attorney. And that's usually what we focus on, especially as public defenders. And so it got us to start thinking out of the box about things that normally wouldn't be a large part of the conversation. So we might complain that our jury pools don't reflect, who our clients are, and they don't reflect the community as a whole in Pima County. And then that got us to start talking about, well, what are the statutes that govern calling jurors, and can that be changed, or do you even need to change it statutorily? It turns out we don't. There could be changes that could broaden who are, coming in as jurors. And some of those are very long-term things, but I think it just really got people talking about the Sixth Amendment as a whole and apart departments and across different positions. And we ended up coming up with both short-term and long-term priorities just from doing that exercise. And then, yes, that's all you wanted me to talk about right now, right?
Yeah, sure. Yeah. No, but I appreciate that, Megan. And and I definitely, it was really interesting to watch the juror pool conversation kind of progress over the couple of years and realize like, well, it seems like this was just something we did because it was a database available at the time, and that really presiding judge could do whatever. So yeah, it was very interesting, and I think something that we're hopeful to be able to accomplish in the long run. Dan, I wanted to ask you, as a participant who kind of came in, we had initially done our self-assessment and then did this as a larger group afterwards, and really tried to make sure that it was open and not directed towards the items that we had previously identified as priorities. I'm curious from your standpoint, what was it like being in the room with judges, with defense attorneys, law enforcement, and of course with yourself as prosecution and some of your colleagues?
Well, it was great not having been part of something like this before. You described it as a self-assessment, and I think that's a really important thing for us. And I've been a career prosecutor. It's a self-assessment. And sometimes, attorneys aren't great at doing self-assessments. We're not great at just sitting there and listening to other people and what their perspectives are. I know that I haven't been great at that. So just sitting and listening to other people talk about what their role is and what their frustrations are. So we had the assistant chief, one of our colleagues with the Tucson Police Department. We had several Superior Court judges, obviously our colleagues over at the Public Defense Services, and just listening to one another and allowing that conversation to really take place was really great. So, we started out by talking about what we're doing well. And I think we all agree there are things that here in Pima County we do very well. We have a fairly robust e-disclosure system. It's mostly paperless. We have a lot of body-worn camera, which is something we discovered was something of a frustration. And, the more we talked about some of these issues, the more we realized that we share frustrations in our jobs. And, body-worn camera that every police officer in Tucson has now creates a backlog of disclosure that obviously it hinders in some substantial way, your client's right to the Sixth Amendment. So in working that through, we came up with several issues that we're to report back on and discuss. One of those was, how do we facilitate making the disclosure of body-worn camera, which is very data and labor intensive, how do we make that better and more efficient? So a couple of the things that we talked about is, and I'd like to highlight one other thing that I think Megan said, is ensuring that paralegals and staff are there as well. Because as an attorney, I mean, we think that we're, holding the ship afloat, but we're really not. It's my paralegal down the hall, it's my secretary, they're keeping us afloat. And so one thing that I realized that was really important is, as I was going through some of the things that were agenda items, I was thinking about how we disclose body-worn camera to defense counsel and some of those inefficiencies. As we're talking about it, I reached out to our chief of our staff here, and she had already been talking with, I think you, Paul, about this previously. And it was, the right hand not really knowing what the left hand was doing. And it's really important that not only we have the dialogue across the street, with public defense services and prosecutors, but also within our own offices. And that was something that that was really important for me to see in doing this self-assessment. So a couple of the agenda items that we talked about is getting the body-worn cameras redacted sooner, trying to do away with the backlog that we have. And some of the items that I think we actually came to resolutions on is that in talking with the staff side of our office, we can do things to make it more efficient. We can, for example, black out the body-worn camera to allow it to be sent over to defense counsel earlier in the process, rather than, we have legal process servers that go through and they redact, which is really labor intensive, any kind of sensitive information in the body-worn camera. That takes a long time. And the frustration from PDS, understandably, is that you can't get that information to your client for sometimes a month or more. And so one of the solutions is that we can simply black it out. Sometimes there's a statement that's on the body-worn camera that you really just need to talk to your client with, or about. And so we can find solutions to getting it sent over to you guys a little bit sooner. So I think that was really important. The big takeaway for me was just the communication, not only, across the street with you guys, but here within our own office.
Yeah, great. Thanks, Dan. Yeah, I actually, since you brought up Assistant Chief Silva, it reminded me of one thing that we were talking about early on with NLADA with, who should be in the room, and trying to figure out how to identify who should be in the room, and recognizing that it really varies by jurisdiction. But one of the things that sort of biasly I knew that PDS, one of our issues was body-worn cameras and disclosure, and having previously talked, knew that law enforcement was one of those individuals who sort of is the bottleneck, not because they're trying to be, but just because they have so many body-worn cameras. But so we had made sure that there was someone higher up in law enforcement coming in, and when Assistant Chief Silva got there, he said, "Hey, can I ask you a quick question? Like, why am I here? I'm more of a Fourth Amendment person, not a Sixth Amendment situation." And he was like, "And I don't understand, and I didn't want to, pre-warn him. So I just kind of said, well, we wanted to make sure to have, stakeholders from all sections and who knows? It might just be that you're a participant who observes how the Sixth Amendment is sort of rolling out throughout this process, and as a third wheel to the prosecutors and defense attorneys, conversations back and forth. But then after he left, he recognized, he really has kind of been one of the leads of one of the main action items that came out of that meeting. So yeah, you never know. Each jurisdiction is going to change slightly, but you never know who needs to be in the room until they're there and they say, oh, you know what, I can actually help with that, or that's a problem that I can help resolve. So yeah, that's a great point. Megan, I know, with public defense services, we've had a lot of different conversations about some of the issues with body-worn cameras, and then also just some of the other issues that we've dealt with just through our own internal assessment. We've seen some really good accomplishments, and we've seen some things, even with the body-worn cameras with Dan and Assistant Chief Silva. I'm curious, from a, management level, how confident do you feel like most of these activities either have been accomplished or will be accomplished within a few years, like they were originally, tasked with doing?
So that's a loaded question right now because we're in the middle of a pandemic, and a lot of the things we were focused on, we were making very real progress on, and those things have sort of come to a halt. But I think we've laid the groundwork for them, and I think we're also in a better position to come out of the pandemic and accomplish them because we've done this groundwork. We now have a body cam working group, which Dan and Chief Silva are part of, that's continuing that dialogue with law enforcement and the county attorney's office, and realizing that the main opposition we have to some of the statutory changes we would need to really not need to do the full redaction for defense counsel to get this more quickly and determine what they really needed to show their clients, or to not have to wait on so much of the redaction, that our main opposition is actually outside of Pima County, that we all agree on a lot of that. And so it's good to at least have that sense of ownership, whereas, we obviously don't always agree on issues. It's an adversarial system, but to see that, there are things that we do all agree on, and that we are all committed to getting clients disclosure in a timely manner and allowing them the right to a speedy trial, to not sit in the jail for months and months just to see some body cam footage that they need to make a decision about whether to take a plea. So I think that was very positive. A lot of our focus has been on increasing the quality of representation at initial appearances, which are done at the jail. And in pre-pandemic, the defense counsel is with their client at the jail, the judge and prosecutor in a separate location. There are some concerns about that setup, but there's also just, we don't have very private areas to meet with our clients right before initial appearances. So it's hard to get information that we might need to make an argument about release conditions to the judge. We realize that our clients are not understanding a lot of what happened at the initial appearance. They don't necessarily really understand what release conditions mean. They don't understand next steps because the information is just given to them very quickly. We did a survey after this and figuring out that was a focus. We hand out cards, informational cards to our clients after initial appearances. And we did a survey and found out there was a lot wrong with the cards. The information that we were giving our clients wasn't being given to them in a way that they necessarily understood. There was information they needed that we weren't giving to them. We were able to change those cards. And, I think the concern for many of us from the defense side is that a lot of what is happening with the pandemic, going more to video court appearances, for example, are things that will seem more efficient and will also, really in the long run be harmful to our clients' right to a fair and impartial trial and right to confront witnesses and all of those things. And so I think by having already done the groundwork for some of the issues we see, such as our clients appearing on a video screen before a judge, we're in a position to already be prepared to make arguments against that if it continues post-pandemic. So I'm hopeful that we've done a lot up front, and that this is just a blip and we'll be able to accomplish a lot of it going forward.
Yeah, no, I know it's also been interesting, and prior to my anti-paperless movement, even in high school. I actually had a saying in high school all the time that we stopped writing things on stone a long time ago so that we could make change more quickly. And I really feel like with the digital age, it's so interesting to see that, like, with the pandemic taking place, we've had to make a lot of changes really quickly. And even with our own goals and objectives with regards to the committee that's been working on this grant, we actually haven't changed focus too much because we're still focusing on access to counsel. But what we recognized is that some of the items have had to sort of give way at the moment for the safety of our clients. And because of this, we've been able to sort of re-engage that conversation and, working towards making sure that we are able to end up having confidential conversations with our clients prior to IAs. And so, yeah, I mean, it is kind of interesting. And I do feel like with some of the groundwork that we already had and some of the conversations that we had about why these things were important, it's really helped us to just sort of respond to this and move into, the pandemic response in the same way of still trying to ensure the Sixth Amendment. So thanks, Megan. Dan, there was a question to you that was, and I'm going to refer it to you.
Yeah. So the question about the body-worn cameras, from the county attorney's perspective, we want to get these disclosed as soon as possible. I mean, our cases can't move forward unless we get all of our disclosure over to you guys. So the body-worn cameras, the difficulty is this. There are two different ways that the body-worn camera has to be redacted. Number one is we can redact out just the victim information and send it over, in usual course. The other thing that we can do is just send over the unredacted body-worn camera over to Defense Counsel. Defense Counsel, all of PDS has agreed that they will be able to review that, and it has some information in there that we otherwise wouldn't disclose. So things like victims, victim information, victim, date of birth, victims' address, those sorts of things that we would usually redact that isn't sent over to a defendant, for example. So if we go the route of just disclosing the unredacted body-worn camera, that includes some of the victim information, we still have to have our process people here in this office redact the video anyway. They still have to go through because anytime a police officer gets inside their patrol car and you have the mobile data, the computer inside the car, it has aegis information. So it has protected, statutorily protected information that we by law cannot disclose to anyone. And that includes the Defense Counsel. So what we have to do is still have people go through the time and effort in our office to go through and actually redact the body-worn camera and blur out screens that might show up in the body-worn camera. And that's labor intensive. It takes a long time. It takes sometimes a month or more because there's such a backlog. And so one of the things that we talked about is instead of having one of our people go through and take the time to redact out each little screen that pops up that might have protected information, we could instead just black out the entire screen, because oftentimes the information that you really need to talk to your client about is a statement, for example, that was recorded on body-worn camera, maybe of their client, of the defendant himself or herself. So that's one of the workarounds, is if we can just black it out, we can send it over much, much faster. And the times that we talked about is, for example, if you have a 1-hour video, you have to go through and watch the video before you disclose it. And that'll take an hour, sometimes a little bit less because you can speed through some parts. But just to black it out took 6 minutes. And so, I have homicide cases where you have, between all the police officers, sometimes you have hundreds of hours of body-worn camera footage just in one case because you have so many officers on scene. And if we're talking about 250 hours of redactions that need to take place, obviously getting them sent over to our opposing counsel much quicker is obviously more efficient for all of us. So that's what I was referring to when I'm saying black out the screen. It makes it to where we can just send it over to counsel to review.
And
Megan, do you want to comment on that?
If I can sort of clarify a little bit more of that too, one of the issues that we're having is that law enforcement is using their body worn camera to do interviews, whereas they used to use digital recorders. And so if, you know, it's a witness interview where there's not a concern about seeing what's going on in the footage, maybe our client just needs to listen to the witness interview. If there's a way to separate out the audio quickly, that at least allows us to hear that statement more quickly, because we used to get recorded statements right away when they were just on digital recorders. And now, because everything is body worn camera, everything is being redacted. And so that's one of the areas that we'd identified.
Yeah, and I just wanted to add one more thing of clarification, because somebody asked about, somebody stated that their body worn cameras are a huge problem in their jurisdiction too. The way that we were able to do this was through an administrative order that was signed by the presiding judge. And so we were able to do it through that means. And that sort of handled some of the ethical issues that we had as defense in not showing our clients certain types of disclosure. And Megan, I don't know if you want to talk at all about that, because I know some defense counsels have had some issues with that. And I don't know if you want to just, obviously not dive into the ethics of it, but maybe just talk about some of that conversation. Oh, hold on, Megan, you're muted.
Sorry. The administrative order it's basically like a gag order, you know, which judges can do. They can say, you know, you can get this disclosure, but you can't show the following information to your clients because, you know, it's sensitive information. And it doesn't happen very often, but what the administrative order did is it said the prosecutor, the county attorney's office they have to redact that ACGIS or the database, the law enforcement database information before we can get it. But what they can do is they can then disclose it to the defense counsel without without redacting all the victim information. And then counsel can look at it so that we can at least tell our clients, you know, in a more timely manner, this is what this video shows. Because a lot of the time, you know, it's going to be, this is an officer who was doing, you know, scene security and was sitting in his patrol car for 2 hours and didn't talk to anyone. And then, you know, our client probably doesn't care about seeing that, but we've at least done our due diligence in making sure we've watched everything. And there wasn't something that came up that wasn't reflected in the police report. And then there will be other, you know, footage that we might look at and our client really wants to see or should see. And so then we request this sort of second level of redaction. The concern was that we're being, I think from some defense counsel, is that we have things in our file that we're not disclosing to our clients. And so there was discussion about that. You know, ultimately, my perspective was always that I'm telling my clients about what I'm seeing and I'm getting it sooner. And then if they want to see it, I'm absolutely going to make sure it gets redacted and they get to see it. But they would have never been entitled to see the victim address in the first place. So I guess for me, it seemed more expedient, but that was sort of what the conversation was about. And we still have this issue of backlog because, like Dan talked about, they're still having to redact the database, the ACGIS information before we get it.
Yeah, thanks, Megan. So I wanted to just let everybody know you can, if you have any questions, you can feel free to type them in the chat. Some have already done that. You could target it to someone specifically, or just leave it open, and we'll try to figure out who would be best to answer that. While I'm letting people think about that, I wanted to go back and just say, you know, Dan, if there was a prosecutor calling from another jurisdiction and said, you know, hey, well, we're thinking about doing this, you know, you recommend it, and what would you make sure is, a part of that process? What would be your answer to that?
Oh, absolutely. And I would absolutely do this again. I think it was a great use of our time. You know, one of the things that you had suggested is even potentially having, say, a client in the room, you know, maybe a former client, giving that perspective. Because like I said before, we don't often get to see the other perspective. And that's really enlightening for us. And as we talk about some of the things that we can do better, it's important to remember that we all start kind of with some of the same frustrations about the system. And just hearing about your perspective, you know, about what we can do better is important for me as a prosecutor, because we really are all looking at the same thing. We are all looking for justice. You know, we have different jobs, obviously, but we really are looking for fair trials and due process for those who are accused. So if another prosecutor from a different jurisdiction asked me, I would absolutely say, yes, do it. And maybe even invite more people to that process from different backgrounds, because that's probably the most important thing that I got out of it, is having the different backgrounds of people that were in the room.
Great, thanks, Dan. And then Megan, kind of a similar question to that. With regards to if defense was calling you, would you recommend making sure that, and feel free to answer, honestly, because obviously I was the one who decided to do it internally first, but would you recommend doing it as a large group, and or would you recommend doing it internally as well, especially for the Sixth Amendment?
Yeah, I would absolutely do both. And I think they serve similar but different purposes. For an organization, it got us talking, and like I said before, thinking outside the box about things we could do to improve. One of the things, Paul keeps talking about starting with things you're doing well, but I think that's also positive. That's important as an organization to recognize that there are things that we're doing really well, which makes the issues seem like, we can actually overcome them, because we know we can. We're doing other things very well. And I think it was good to have the conversation and focus on short-term and long-term goals within the organization, because there are things that we can do within our organization, like the IA, the initial appearance card, that we don't need to really get other stakeholders involved in, to a certain extent, but not significantly. And then, I think having the larger group is very important, because there are a lot of the things we're talking about that we cannot do ourselves. We need to get buy-in from the other members of the criminal justice system. And some of that, we'll be able to resolve. And some of it is just starting to have the dialogue so that we all hear where each other are coming from, get each other's perspectives, and then, at least start talking about some of these issues. So I would recommend doing both.
Great, thanks, Megan. Yeah, I did want to just reference the chat. Kate put in a link there to the website for the anatomy link. And then also there's a short survey there. And with that short survey, I also want to just do a call to action to the attendees from other jurisdictions. One of the things that I also really enjoyed and was Lisa Vavanes from the Center for Court Innovation was doing this activity for others, and then really kind of shared some of them. She wasn't allowed to share all of them, obviously, but some of them she got permission to share with us, because there were similar problems that we had, and they came up with a different resolution to it. And so I just want to encourage everybody that if you are doing this, do reach out to NLADA, let them know, maybe let them know kind of the answers. There's some exploratory conversation going around about how we could potentially share that information with other jurisdictions about, hey, we came up with this and this was our resolution. And obviously, each jurisdiction's unique in some sense, but oftentimes what I have found just in talking to other jurisdictions, even outside of this activity, is that really a lot of times someone else has come up with a solution that if tweaked in the right way, works well for us. So feel free to reach out to NLADA if you do this activity and let them know. And then the last thing, Monica asked about where is the PDF of the exercise. So it is on the website. So it's the first link that Kate sent, strengthen6.org/articulate. And then after the introduction, if you move into the instructions, it's right there in that tab. I think you have to hit continue once. And then you'll see the PDF there that you can download. And if you have any problems with finding that, there's also a list on the link on the top right where you can get technical assistance, and you can reach out on that, and then people can help you. Also with technical assistance, if you wanted someone to do this as sort of a neutral party. When we did this internally, I sort of led it, but then when we did it as a larger criminal justice group, fortunately we had the Center for Court Innovation available to do it, so that there was sort of a neutral party that was available to sort of lead all of that, which I think can be very helpful as well, just to make sure that everybody feels like they're on equal playing ground. So I just wanted to thank Megan and Dan for your time and for being a part of this. And then Kate, also thank you, and Maria and NLADA for hosting this. And I just thank all of you and hope that you have a wonderful day and continue to stay safe and healthy.
Thank you so much, Paul. We really appreciate it. Thank you to Megan. Thank you to Dan.
Yeah. Yes, thanks to all of our panelists and to all of our attendees. We'll send follow-up emails with everything as well if you don't grab it here in the chat today. But we're going to bring this to a close, and thank you so much, everybody, for taking part of your day today to hang out with us virtually.
Kate,
so much.
before you jump off, there is a question. I don't know if anybody said that might want to answer what the judiciary's reaction was to the tool. I love that question.
Oh yeah, I tried to get one of the judges to attend, but he just wasn't able because he had a conflict at this exact time. But I don't know if Megan or Dan, you guys were actually sitting at the tables. If either of you want to share quickly what your thoughts were on how the judges were responding, and I'll go to Megan first and then let Dan go.
Yeah, I felt like that was one of the more useful aspects of it. The judges participated. One of them was a former prosecutor here. Another one was a former prosecutor from another jurisdiction. They were, I think, two of them were currently on the criminal bench. And I think, for them, even just hearing, they would hear about we need continuances, but actually, hearing about how the body-worn camera is impacting how slowly cases move, they hear it from us, but I don't think they really hear it when we ask for the continuances. And I think having them part of that discussion and really hearing about what was going on behind the scenes was very important so that they have a little more empathy for what we're going through. I thought it was useful.
Thanks. Go ahead, Dan.
I agree completely with what Megan just said. I think the judges hearing what's going on behind the scenes. I mean, sometimes I think we both probably feel like the judges think we're just all dragging our feet when we don't get disclosure or we're asking for another continuance. I think it was good for the judges to kind of have their eyes opened in a way to see kind of what's going on behind the scenes, what we really are working towards getting accomplished. So that was the good part about it, is having the judges there and watching.
Great. So hopefully that answered that person's question. And all right. I'll pass it back to you, Kate.
No problem. Well, that brings us to a close today. Again, thank you to everyone for coming out and taking the time to do this virtual thing with us that we're getting better at every day and day. But we hope to hear back from you soon through the survey, or if you do the exercise yourself in your jurisdiction, we would love to hear about it. Thanks so much.
Thank you so much.